Hello, welcome to the Rights View channel. I'm Suhas Chakma. Arunachal Pradesh has been in the claims over the recommendation of the Joint High Power Committee to grant permanent resident certificates to the communities such as Deoris, Sonowal Kacharis, Morans, Misings, and ex-servicemen belonging to the Gorkha communities of Namsai and Changlang districts in the state. 2 persons have died and many injured while private residents of the Deputy Chief Minister Chona and properties belonging to Nabam Rebia, who happens to be the chairman of the JHPC in Itaganagar, had been burned down. The state government yesterday decided not to act on the recommendation of this Joint High Power Committee. Today we have Mr. Suhas Chakma, Director of the Rights and Risks Analysis Group, to explain the various issues. So, with the decision of the state government to not act on the recommendation of the committee, do you think this problem of the PRC has been resolved forever?
No, the issue of the PRC has not been resolved. It has been postponed, and it involves the rights of these 6 community who are substantially numbered in these 2 districts. Obviously they shall continue to demand, and at the end of the government of Arunachal Pradesh has to find a solution to this problem.
And so what do you think, are only the scheduled tribes belonging to the state of Arunachal Pradesh, are these the only communities who are entitled to these permanent resident certificates?
See, the permanent resident certificate has nothing to do with the persons or the communities having scheduled tribe status or not. Issuance of permanent resident certificate is a completely different process, and if you look at the requirements as to who will be eligible and who will not be eligible, obviously a state shall not only have the scheduled tribes, it shall have other communities, other people also. So therefore the grant of permanent resident certificate has nothing to do with the status of the person being a scheduled tribe or not being a scheduled tribe.
So, is the grant of the PRC in any way linked to with the inner line permit?
See, the inner line permit is once again completely different set of regulations. By the very definition of inner line regulation, which is under the Bengal Eastern Frontier Regulation Act of 1873, it applies to somebody who is visiting temporarily from outside the state or the district when it was notified. So it is not applicable to somebody who is born and brought up in the state. So therefore you have to keep in mind that inner line regulation is for outsiders. It's not for the insiders who are already settled there, born and brought up there. So it is no way connected with the inner line regulation also.
So are these communities like Deoris, Sonowal, Kacharis, Morans, the Misings, are these outsiders in these districts of Changlang and Namsai?
No, definitely not. They are indigenous to these districts. You have to remember the history of these 2 districts. Changlang and the Namsai districts were respectively brought out of erstwhile Tirap district and the Lohit districts. And the Lohit district as well as the Tirap districts, we are actually part of the Tirap frontier. These peoples are not outsiders, they are indigenous to these lands and territories. You have to remember the history of Changlang and Lohit districts, which we are not in any way outside the states. The Changlang district was part of Tirap district, and Tirap district actually came out of the Lakhimpur Frontier Tract. So Lakhimpur Frontier Tract was actually also consisted of the areas which was Lohit district, out of which the Namsai districts had been brought out. So historically, if you look at it, both these districts, we are actually till 1954, we are part of the Lakhimpur districts till 1954, when the Northeast Frontier Tract was actually turned into Northeast Frontier Agency. So if you were to say that Misings, the Sonowal Kacharis, Deoris, etc. are outsider to these areas, I think we need to look at the historical fact that 1873 Bengal Frontier Regulation also regulated the Lakhimpur Frontier Tract, out of which the Sadia Frontier Tract had come out, out of which Tirap Frontier Tract had come out, and these are historical facts, and these are boundaries which we are drawn in the post-independent India. And post-independent India, when the NEFA was turned into Arunachal Pradesh as a union territory and thereafter as a state in 1987, the origin of the people, especially these 5 communities, you cannot decide based on the current boundaries. Historically, they were part of the same tract, that's the Lakhimpur Frontier Tract, which was governed by, the 1873 Bengal Eastern Frontier Regulation.
What about the Gorkhas?
See, the Gorkhas, we are taken there for their contribution to the service, as well as, to protect the nation after 1962 war with China. So therefore, once they were taken by the government of India to settle there permanently, they become permanent residents there. If you look at the inner line regulation or the Bengal Eastern Frontier Regulation, who is the competent authority to issue the passes? The competent authority to issue the passes for inner line is actually the district magistrate. District magistrate on his own is not an independent authority. District magistrate is a servant of the government of India, and once the government of India has decided the Gorkhas will be settled there, of course they become permanent resident there. And after 55 years or 56 years, you cannot say that they are no longer the permanent residents of the state. So the entire process of identifying either the Gorkhas or the erstwhile residents or the inhabitants of Lakhimpur Frontier Regulation or Frontier Tract as outsiders is absolutely unfortunate.
So who are eligible to get the status of these permanent resident certificates? What does the provision, the law says?
See, there is no provision. The grant of permanent resident certificate in Arunachal Pradesh or elsewhere is not based on the law. It's essentially the government comes out with an executive order, and those executive orders, they may say that you have to fill up this document, you have to produce this document, and etc. etc. In the country, there is only one law which defines a resident who is an ordinarily resident or otherwise. That's the Representation of People's Act of 1950 under the section 20 of the Act. So therefore, if you look at the PRC is not, or the submission of applications or the requirements of the documents under the PRC are not based on any law. It's just that nobody has challenged the legality of the requirements. Say for example, if you look at the PRC documents, if you look at the requirements or the documents to be submitted to the PRC, it says that you have to provide the proof of the land ownership. Now, are we to presume that there are no landless people in Arunachal Pradesh? So a scheduled tribe who may belong to, say, Adi, Nisi or Monpa community today does not have any land document in his or her possession, and he or she will not be qualified to get the permanent resident certificate. Obviously that cannot be the law. So whatever has been done with respect to the PRC is an executive decision, and some of these decisions are absolutely arbitrary and do not meet the requirement of the law, and they shall be struck down if somebody challenges before the court.
Why is there such a hue and cry on this issue?
I think the hue and cry on this issue is actually based on the misinformation campaign which has been created. People in Northeast India do not know or do not sometimes consider to read the history, that the fact that these two districts, the erstwhile Tirap district and the Lohit districts, we are part of the Lakhimpur Frontier Tract. In fact, Lohit district was the Mismi Hill district tract. These were part of Assam, and they were governed by the Eastern Bengal Frontier Regulation, is possibly not known by people. And what has happened in Arunachal Pradesh is that people see the PRC as something linked with the scheduled tribe status. Now, who is a scheduled tribe in Arunachal Pradesh? If you read the census report of 2011, it's very clear that any tribes of Arunachal Pradesh is a scheduled tribe, and as per the constitution scheduled tribe orders, as illustration, it actually gives the names of 16 communities as an analogy. That doesn't mean that other people who have been resident in Arunachal Pradesh are not scheduled tribe. So the census report says the definition of scheduled tribe, or who is a scheduled tribe, is an open definition, though there are only 16 tribes who are mentioned in the list of the scheduled tribes. In fact, when the census was conducted in 2011, about 100 communities have identified themselves as scheduled tribe, and some of them are as small as 5,000 persons. So the people who have been included in the scheduled tribe list, today they are actually questioning the first definition of the constitution scheduled tribe order or Arunachal Pradesh, which says all tribes of Arunachal Pradesh, including so and so. It is not excluding, including so and so, and this process of identifying, or this process of trying to create an exclusion process contrary to what the Constitution Scheduled Tribe order says, is, I think, the root of the problem.
Thank you very much, Mr. Chakma. Thanks for watching. Please subscribe to the show.